Senator Caligiuri, Senate Amendment C.
Thank you, Mr. President. I asked the question to make the point that I believe we all, if only implicitly, acknowledge that three strikes is a useful concept because we adopted the idea of an enhanced penalty for a three-time offender when we all adopted Senate B. So having done so, the question of the usefulness of three strikes as a concept, to me, is no longer debatable. We've conceded that point. So the issue isn't whether it's useful or not. The issue is, what is the appropriate sentence for someone who's been convicted on three separate occasions of committing these most serious violent crimes? That's not a question of usefulness. That's a question of what is the appropriate sentence for an individual who faces these particular facts. And so I reject the notion, in this senator's opinion, that this is a question of whether a three-time enhancement is useful, because I believe those of us who voted for Senate B have all acknowledged in one form or another that it is. So the only question is, what is the appropriate sentence enhancement for someone who falls under those circumstances? As someone who has been arguing from the beginning for three strikes, I, for one, and I have not heard any person who has argued for three strikes say that it is the cure-all, the single solution. I've never said it. No one I know who's argued for three strikes has ever said that. What we have said from the beginning is that it is one very important part of a comprehensive solution to dealing with our criminal justice system. So this is not a bumper sticker slogan. It is not a cheap trick. It is part of an important, comprehensive approach to dealing with our problems. Even the Pettits acknowledged that three strikes would not have stopped what happened in their situation. But it didn't stop them from understanding that, notwithstanding that fact, there was an important public policy goal to be achieved by enacting a three strikes and you're outlaw. I will note, and I've talked about it, although it hasn't gotten as much attention as I think it deserves, there is a case that came out of Waterbury several weeks ago where a three strikes law could have made a difference in the murder of a young 20-year-old woman by a Mr. Cowan. And I believe if we looked, there would be other examples where a three strikes law could have been helpful, even if, in fact, it may not have prevented the horrific act that occurred in New Britain or, for that matter, in Cheshire. In terms of the public safety issues, we've had this discussion before. Commissioner Danaher originally raised the issue of whether this would increase violence against law enforcement officers. We researched that question, and then we talked to him, and he conceded that there's no research that he is aware of that has ever determined that enacting this kind of a law would increase violence against law enforcement officers of any type. And in fact, since that time, Commissioner Danaher has now become one of the staunchest supporters of three strikes that are out there. So I don't believe that is a valid concern. And I guess let me wrap up by saying, when we inevitably send out our mailers saying that we voted for a bill to triple the minimum sentence for three-time violent criminals, if a constituent were to do the research and say, for manslaughter first, doesn't that really only mean that you increase the minimum from 1 year to 3 years? Would we still be as proud of what we did? Would we still be able to stay as strong in boasting about that accomplishment? I suggest that if our constituents knew those facts, they would not be nearly as impressed with this legislation as many of us would like to think they will be once we start talking about it. I don't believe it goes far enough, and I respectfully urge the body to adopt it. Thank you.
For your remark.